Good morning, friends. Namaskar, Sat Sri Akal and Adab. This is my 226th video, and today we will cover a very important subject. The series I will be covering will be regarding the sales. Now, lately we've been asked to garner an NOC from the Ministry of Defense, and the 2011 judgment of Varanasi in Allahabad High Court, which has restricted sales of all cantonment properties without the permission. Now, let's presume what was happening in 1793 when there was no documentation, no Registration Act 1877 or the Transfer of Properties Act 1882. So were registries happening prior to these two things, 1877 and 1882? So we'll gradually understand how things were moving under the regulations, rules and acts, other than under section 10 of the Act 1865. Now this is prior to the Cantonment Act 1864. After was the maintenance of sale deeds being done, and after the making of the Act 1865, where were they being kept? They were being kept under section 10. So will the department come with the truth, or will it again lie down that these registries which were being made by this Act of 1865 were basically grant deeds? So there were 4 statutes which were dealing, and all of these were moreover considered by the then Governor General, which was that these statutes were fraud, and they had a calendarized situation of even mortgaging these properties. Let's presume, yes, the Governor General was right. So the Act 9 of 1842, the Governor General repealed all these sections and further came up with new orders. So that means in 1842 and prior there were sale deeds taking place. So the Bengal Regulation I of 1798 and Bengal Regulation XVII of 1806 were totally repealed by this 1842. So there was another act of Bombay Presidency where Regulation V of 1827, only one section 15 was repealed. So this is how these statutes were being repealed and modified. So Bengal Regulation 8 of 1809 was either repealed. So then came the Awadh Law Act of 1876 and the Punjab Law Act of 1872. So they had their own customs, own systems of how sale deeds would be, and these statutory orders would be recognized. So that means sales were happening from 1793. So title deed, which is a testimony to the level of subversion and breach of laws with particular references to the Land Revenue Act. Now what does this mean? And the devolving rights which were severely being jeopardized. Restorations had to be done under the TPA Act, under the Registration Acts. So now coming to CLA rules in 1925 and CLA rules in 1937. So Rule 3, 4, 10 and 45 have not been observed in proper obedience by the department. The title deed is not representative of the original rights lawfully, as it was illegally subverted under influence of the cantonment authority, also supported by a document on record of rights, page 19. Therefore, the DO or the MEO then has been in hand in glove of the unconstitutionality and is under a criminal conspiracy of subverting the rights of the proprietors and favoring the rights of the government, wherein instead that the government had no rights in the soil. As per CLA Rule 4, we were Category 3 lands, and the only authority which could govern us was the three principals: the sanitation inspector, the taxation inspector, and the building inspector. And these were for the health, hygiene, and the stability of the British Army troops. So, by merely writing Rule 10 and 45 and taking the management of the GLR only during the Government of India, lease of this property is to be treated as public premises. Why? Because it's being managed by the Defence Estate Officer, and Defence Estate Officer comes under the Government of India or the Ministry of Defence. Similarly, there is Hudda, there is Pudda, there is DDA, which is directly under the state government, subject to the state laws under the land as per the constitution, and we are governed by the constitution under the land matter of Article 246. So this has to be understood. We were even derequisitioned, where in Rape Act it is written. Once you are derequisitioned, the property is handed over to the original owner. But what has happened that our properties were requisitioned and they were never derequisitioned. That is why old grant remained there. Now, if these properties are derequisitioned, so it has to go back to the original old grant holder or the proprietor. We can make good, the government can make good, take away its building, hand back the land which was taken. Must have been in 1843 for Ambala and various dates. Now there is a registry number 126. Words used in this registries are acquired. Now acquired as per section 1110, whether the cantonment authority has acquired through the cantonment fund this property, or whether the definition of grant or the registration of a grant, can it take place? Grant Act speaks something else. So once when we come to the word acquired, what is the dictionary meaning of it? Comes to possess as per law lexion. So lands were to be given and on a specific grant size. So we are holding strange sizes. As per the rank of the officer, none of these grants have similar sizes. Talking of Ambala cantonment, none of the bungalow is having similar size. One is 1.82, one is 3.4, somebody is 4.7, somebody is 5, somebody is 8. So the cantonment code of the regulation of the PWD 1858 subjected to 1810 has been totally demolished. So we were basically holding these sale deeds, registrations starting from 1793. So we have to be very cautious. Now, whether settlements of these cantonment areas ever took place, it's very important. Let's say my cantonment was made in 1843, Ambala. Was Ambala by 1843, the settlement of land was conclusive? Is there any report which says no? The record of rights very clearly says that there were no settlements done in these cantonments, because land was already taken over by the British officer to build a house from the original old grant person or a proprietor, whether it was a Badshai grant or whether it was a non-Badshai grant. So once when this has happened, so these registrations in these documents should come forward, because they will only speak the truth. Now Talking of Purushottam Das Tandon, he showed a sale deed of 1865. Talking of Pune Ghaswala case 1911, he equivalently showed his sale deed somewhere of 18, I think 60 or something. Where are those documents? Under which registration or TPA Act or Governor General orders were these registrations coming forward, or were they done under the Cantonment Act 1864, subsequently taken to 1924 when the abolishment of the Cantonment Magistrate took place? Friends, we all need to understand that registrations were being done minus the TP Act, minus the Registration Act 1877. So please dig into your land records, because once you get that land record of your cantonment, you ought to be an old grant and you were revenue free grants, never converted into new grants by the Britishers either in 1765 or 1790 or 1812 or 1822 28, sorry, and last 1859. Why am I using these dates and years? Is very important in the research material. So friends, wake up. Thank you. Good day.